In this lecture, we would like to discuss Lone Fuller. And as Lone Fuller is a contemporary renowned jurist of the new revival natural law in 20th century. So, in his work, The Law in Quest itself and the Morality of Law, where he discussed the competing claims of legal positivism and natural law. And according to Fuller, legal positivism and natural law are two different directions of legal thought and are two rival systems. As legal positivism, he defined is that direction of legal thought which insists on drawing a sharp distinction between that law is and that law ought to be. On the other hand, natural law in view to which he defines the possibility of a rigid separation of the is and ought, and which tolerates confusion between them in legal discussion. In other words, most systems of natural law not only tolerate a confusion of is and ought, but insist upon a complete identification of is and ought. So Professor Fuller reminds us many systems of natural law, but one thing that unites them is certain of the is and ought. So Fuller commands the natural law philosopher who directs his energies towards more profitable employment than attempting to separate the inseparable. So, Professor Fuller traced the minimum weakness of legal positivism and its inherent weakness of the law's quest for some exclusive command where it may start free from ethics and philosophy. So, according to him, there would be no rigid separation of law and morals. So, it would be very difficult to make a strict separation between law and morals. And as such, Professor Fuller, as he revived the natural law in 20th century and in his work The Morality of Law, he exactly enunciated the morality of duty and the morality of aspiration. And as regarding that, he expressed that the very morality of duties as moral duties, and these moral duties demands of social living as while morality of aspiration or moral ideals, and it aims at fullest realization of human powers. So, according to Fuller, morality has many usages and several meanings, and he is interested in morality as it is and morality as ought to be. So he attempts to make a distinction between the morality of duty and morality of aspiration. In his own words, he described this morality of duty as the moral duties and the morality of aspiration as the moral ideals. So, he further divides moral duties into affirmative action and forbearance, understood as moral duties, as moral prohibitions, or affirmative and negative duties. So also he further break down into two basic subcategories such as personal virtues, for example, courage and social ends as justice. And Professor Fuller makes distinction between morality of duty and morality of aspiration. So, according to him, morality of aspiration is the morality of good life, of excellency, of fullest realization of human power. So, he made a contrast between morality of duty and morality of aspiration. As such, morality of aspiration, in that connection, would like to cite certain examples of the fullest realization of human power. So, as in case of a young damsel sacrifice her social life for her aged and widowed father, and so also in all these cases, such as where an individual reflects his fullest realization of human power by achieving excellence in his respective sphere of actions and duties in furtherance of the advancement of the society. So, it would be considered as the morality of aspiration. It further consists very largely a life of abstinence, and as such, to Fuller's moral duties are very sticky and inflexible, while it is the nature of all human aspiration towards perfection to be liable and responsible to changing conditions, etc. So, the very nature and concept of law as regarding Professor Fuller's. So, we have discussed the very differences between the two, that is, moral duties and moral ideals. So, as regarding moral duties also, he mentioned the very demands of social living. So, the society made certain demands for social living from individual, and as such, one has not to indulge oneself in such actions like gambling or in a way involvement in any sex activity which are considered as demands of social living, and according to Fuller, these are falling under moral duties. And as regarding moral ideals, it requires good life, excellence, and a fullest realization of human powers. So, also, the very utility of the distinction between moral duties and morality of aspiration is useful, as it provides a partial inventory of elements of law and is helpful in understanding comparison between law and morality. So, these are the very differences that we found made by Professor Fuller in between morality of duty and morality of aspiration. And now we'll discuss about Fuller's idea about concept of law. So, according to him, law as a purposive system. So, in that sense, also he describes the inner morality of law. And regarding that, he provided the eight important requirements which must comply by the legal system. So, according to Professor Fuller, law as a purposive system, and its particular purpose being that subjecting human conduct to the control and guidance of legal rules. Law is the enterprise of subjecting human conduct to the governance of rules, and regarding that, Professor Fuller lays down eight important requirements, and that he called as the inner morality of law, and it should be in a legal system, and that legal system must comply with these eight requirements. So, these eight principles, as laid down by Professor LON Fuller, as the first requirements or the principle as laid down by Professor Fuller is there must be rules. Second one, the rules must be publicized. And the third principle which he laid down, laws, retrospective legislation must not be used abusively. And the fourth principle is that the rules must be understandable. And the fifth principles or requirements as laid down by Professor Fuller is that the rules must not be contradictory. And the sixth requirements of inner morality of law is that the rules must not require conduct beyond the power of the affected parties. And the seventh requirement or the principles of inner morality of law is that the rules must not be changed so frequently that the subject cannot guide his actions by them. And the eighth or the last requirement, as laid down by Professor Fuller as his inner morality of law, is that there must be conjunctions between the rules as announced and their actual administration. So, as Professor Fuller expressed, a ruler who tried to subject human conduct to be governance of rules but failed to fulfill these conditions would fail in his purpose. Hence, the fulfillment of all these requirements of inner morality of law is necessary to subject rule of law to this demanding process of law. So, these eight requirements, as laid down by Professor Fuller as inner morality of law, must comply by the legal systems, and as such, these are the procedural version of a new natural law which was revived by Professor Fuller in 20th century. So you'd be considered as the revivalist of the new natural law version of the 20th century. And as regarding that, he made such a contribution. And in that connection, we would like to discuss about fuelers and the very contribution of his natural law and the very criticism of positivism. So, Professor Fuller says that it is difficult to draw a sharp line between is and ought in any field, especially in legal theory. Both is and ought are a part of human experience, and the line between the two melts away in the common stream of common sense motivated towards a purposive activity. So, in his the morality of law, Fuller maintains that the purpose of a legal system is to subject human conduct to the governance of rules. The law, therefore, cannot be devoid of moralities, and without much which it cannot be called law. Fuller's purposive picture of law takes into account the internal and the external moralities of laws like values, ideals, natural law, and justice, and which, according to Professor Fuller, are the inner morality of law. And these inner moralities of law must be complied by every legal system to succeed. And as according to him, law as a purposive system. So both is and ought marges for law. March for law is a precondition laid down by Professor Fuller for a good law. So, we have completely evaluated and explained the philosophical departure made by Lone Fuller as a revivalist naturalist of 20th century from the traditional natural philosophies of those natural philosophers like Hobbes, Locke, Rousseau, Saint Thomas, Aquinas, etc., that already we have discussed. And here, Lone Fuller laid down the new revival aspects of the new natural law of 20th century in his famous work, The Law in Quest of Itself and the Morality of Law. So, his main argument is that it would be impossible to make a separation between law and morals. So, it would also be wrong to make a distinction between law that is and law that ought to be, and to exaggerate it and to explain his views. He laid down morality of duty and morality of aspiration, such as moral duties and moral ideals. And if one is demands for social living, the second one is for fullest realization of human powers. So, basically, Professor Fuller considered law as a purposive system. So, we have completed our very discussion on the philosophical contribution of Professor Lone Fuller.